This is Legal Foundations Class 22, Spring 2019. Our general strategy for today is talking about reading comprehension review. Remember, as you read, we want you to question the question. This will help you determine what the narrow issue that the examiners are testing you on. As you read, question the question, think about the following things. Note that several of the phrases are in red, and those are ones that you should primarily focus on. Is the suit civil or criminal in nature? Who are the actors? What are the parties? Where are the parties from? What adjectives, if any, are used to describe the actors or parties? What are the actors or parties doing? What adverbs, if any, are used to describe how the actors or parties are acting? If there's an agreement, is it written or is it oral? Is there, say, an integration clause in there? If there's an agreement, what does it say? If there's a sequence of events, what's happening when? This is particularly important for contracts and real property. What do the actors think they are doing? Can you rephrase the question in your own words? Can you rephrase the answer choice in your own words? So, for pre-trial motions, these are motions that are made sometimes as the first responsive pleading, but can occur anytime before trial takes place. So, most of the motions are based in Rule 12b, and the key is to watch out for timing. So, 12b1, lack of subject matter jurisdiction. This is never waivable at any time. This can occur even when the case goes to the Supreme Court. So if you file a 12b1 motion, this can be filed at any time. A 12b2 motion for lack of personal jurisdiction is waivable. You must object to personal jurisdiction in your first responsive pleading. Improper venue is also waivable. Insufficient service of process or insufficiency of process are both waivable. Again, 12b2 through 5 must be raised in your first responsive pleading. If you fail to do so, you waive that defense. For 12b6, failure to state a claim, or 12b7, failure to join an indispensable party, these are waivable, and these can be done for 12b6 before or during trial, in which case the court can dismiss with prejudice, dismiss without prejudice, or they can grant the plaintiff leave to amend the complaint. Remember that the court has a lot of flexibility in doing so. The standard is as justice requires, so they could grant the plaintiff leave to amend the complaint. So when will a court dismiss a complaint under 12b6? A court will dismiss a complaint if it fails to state a cognizable claim, if it provides insufficient facts, or contains an allegation that negates one or more elements of the cause of action. Discovery is the process whereby parties exchange material. Discovery can be had of any non-privileged matter, so not attorney-client or work product, that's relevant to the claim or defense of any party and is not reasonably cumulative or burdensome. Supplementation. So a party must supplement a discovery response with any information that would have been subject to mandatory disclosure requirement initially. Even if the opposing party does not request the information, you have a duty to supplement your discovery response if additional information comes up. If you have inadvertent disclosure of privileged material, you can still invoke a claim for work product or privilege by notifying the other party. So once notified, the other party cannot use or disclose the material, which must be sequestered or destroyed. Oftentimes in discovery plans, there is an automatic clawback whereby parties can claim privilege on material and it doesn't have to go through a discovery fight. Protective orders can be part of discovery, and protective order is issued to limit the nature and scope of discovery. Sometimes Protective orders are for the purpose of limiting discovery. They may limit the amount of documents. Sometimes a protective order is put in place because they want to limit the disclosure of embarrassing material. And sometimes protective orders are used for things like trade secrets. So what are your required disclosures under Rule 26? So Rule 26 required disclosures must be disclosed without request. So your initial required disclosures, these must be done within 14 days of the Rule 26 conference. So you have to disclose the identity of persons that will likely have discoverable information that the disclosing party may use to support its claims or defenses. Copies or descriptions of documents, electronically stored information or ESI, and tangible things in the disclosing party's possession or control that the disclosing party may use to support its claims and defenses, computation of damages claimed by the disclosing party, and copies of insurance agreements. Now, under Rule 26 initial disclosure, you don't have to disclose information that will be helpful to the other party as part of its Rule 26 initial disclosure if they are not using that information to support their own claims or defenses. For experts, you need to disclose it usually at least 90 days before trial. You have to disclose the identity of experts and any reports that they have prepared. Now, what happens if you have an expert that is not expected to be called to testify at trial? A party cannot obtain facts or opinions held by an expert retained in anticipation but not expected to testify at trial unless the party shows that it's impracticable to obtain the facts or opinions by any other means. And pre-trial, at least 30 days before trial, a party must disclose witnesses and a list of documents or exhibits. So what would be confidential or protected material? First off would be work product. A party may not discover documents or other tangible items prepared in anticipated litigation or for trial by another party, its representatives, including an attorney, consultant, surety, indemnitor, insurer, agent, researcher, private detective, etc. So, on the MBE, one party will get a witness to write or sign a witness statement. The other party wants to get discovery of that statement. Can they do so? It depends. There's qualified immunity, which is a presumption of immunity from discovery can be overcome if the party seeking discovery has a substantial need and cannot, without undue hardship, obtain the material or equivalent through other means. So there has to be a substantial need, and there has to be undue hardship in obtaining the materials or their equivalent through other means. There's absolute immunity as it pertains to the disclosure of mental conclusions, opinions, or legal theories of a party's attorney or other representative concerning the litigation. So here's an example. So if plaintiff, an African American, goes to a restaurant where he's insulted on racial grounds by a waiter. W, a customer sitting at another table, witnesses the encounter. There appears to be no other witness. So then plaintiff sues the defendant for a federal statute prohibiting racial discrimination in place of public accommodation. And as part of the defense preparation to defend the case, defendant's lawyer interviews W and induces W to write and sign a statement about the encounter. The plaintiff's lawyer seeks discovery of the copy of the statement. Since the statement was prepared in anticipation of litigation or for trial by another party's representative, the statement can't be discovered unless the plaintiff can show that there is a substantial need of the statement in order to prepare the case and that they cannot, without undue hardship, obtain the substantial equivalent or the statement throughout those means. So if they could prove those two things, they could get a copy of the statement. Now, let's say that the lawyer takes that statement and annotates it, handwrites in their own, by their own hand. Let's sure to have W emphasize this point when we call him at trial. That handwritten note is a mental impression or conclusion, and that notation is absolutely immune from discovery. So if they were allowed to get the interview statement, they would get a copy without that mental impression annotated on it. So there's two types of privilege materials. There's attorney-client privilege and there's work doctrine. Does the attorney involvement have to be required in attorney-client privilege? Yes. Work product? No. It can be created by the client. It can be created by a representative of the attorney. Is there a communication required? Yes. For attorney-client privilege, thoughts, not communication, are generally not protected. Work product doctrine, no. Uncommunicated documents may qualify for protection. Must the communication relate to legal advice? For attorney-client privilege, yes. For work product doctrine, no. It depends on the substance. Is litigation required? For attorney-client privilege, no, it's not. Work product, yes, because remember, these are prepared in anticipation of litigation. Can it be overcome by the other party's needs? No, for attorney-client privilege, that privilege is absolute. Yes, for work product doctrine, remember, if it's qualified immunity without the mental impressions, conclusions, opinions, or legal theories of the attorney, they could obtain that fact work product. But opinion work product is not discoverable. So what are the discovery tools that parties can use to gain information? You can do depositions. If it's a non-party, they must be subpoenaed. The party requesting the deposition must also provide for the attendance of witnesses, usually by serving a subpoena. Interrogatories are written questions. These may only be addressed to parties. So if a question answer is interrogatories towards a witness who is not a party, you know that's the wrong answer. In a situation where desired information may be ascertained from business records of a party on whom the interrogatory is served, and where the burden of finding the information is substantially the same for the party serving the interrogatory as it is for the party served, it is a sufficient answer to provide the serving party reasonable opportunity to examine the records. You may not have to produce the records, but you have to provide a reasonable opportunity for the party to examine the records. There's a request for documents. There's a request for admission. And there are physical or mental examinations. To get a physical or mental examination, you have to have either consent or court approval. It requires a showing of good cause and only relates to conditions put in controversy. So if you have a physical injury because of a car accident, they can't seek a mental examination unless you're also adding IIED or NIED or something else that would raise the issue of a requirement for a mental examination. So where a person's condition is in controversy, a physical or mental examination may be requested. Physical and mental examination are the only discovery tools for which advanced court approval is required. You have to have a showing of good cause in order to get the examination. Motion for summary judgment. This is either a partial or entire motion for summary judgment. Why do parties like motion for summary judgment? Because you can use a motion for summary judgment to dismiss issues or the entire cause of action. A motion for summary judgment will be granted if the moving party shows there's no genuine dispute as to any material fact and the moving party is entitled to judgment as a matter of law. Unless there is a local rule or court order that provides otherwise, a party can file a motion for summary judgment at any time until 30 days after the close of all discovery. Evidence presented with the motion for summary judgment will be viewed in the light most favorable to the non-moving party in determining whether the moving party is entitled to judgment as a matter of law. So, if both sides agree regarding material facts and given those undisputed facts as a matter of law, no jury could properly find for the non-moving party. Or, although the parties disagree with the existence of at least one material fact, the non-moving party has not been able to show that it has admissible evidence sufficient to allow the jury to properly find for it as to that fact. So you can get the whole case essentially dismissed if you prevail on a motion for summary judgment, or you can get some of the issues or elements disposed of through a motion for summary judgment. The timing for a motion for summary judgment is at any time until 30 days after Discovery concludes. For evidence or response, the plaintiff could not rely on allegations in the complaint to defeat a motion for summary judgment by the defendant. Plaintiff must produce evidence in support of each element of its cause of action. Evidence in support or defense of an MSJ must be admissible at trial. On the MB, if the validity of the claim turns on whether a party behaved negligently or whether a party acted with a certain state of mind, the case is generally unsuitable for an MSJ. It's going to have to go to the jury. And remember, if the plaintiff is filing an MSJ, the burden is on the plaintiff to affirmatively prove each and every element. So, pretrial conferences. Pretrial conferences are a means of organizing the trial calendar, handling motions issues, and things like that. So, your first pretrial conference is a Rule 26F conference of the parties. This is planning for discovery. So, as soon as practical, and absolutely before you have your 16B conference, you must have your Rule 26F conference of parties. The parties confer to consider claims and defenses, a possibility of whether the case will be settled, initial disclosures, any plans concerning preservation of evidence, and a discovery plan. Rule 16 scheduling conference is held by the court. This limits time for joinder, motions, and discovery. It sets dates for pretrial conference, trial, and other appropriate matters. Lastly, you will have a pretrial final conference. And this is held as close to the time as trial as possible. And the final conference is for the purpose of formulating a plan for trial, including admission of evidence. This has to be attended by at least one lawyer from each side who will actually be conducting the trial on any unrepresented parties. The court will enter an order after the conference that acts as a blueprint of the trial, listing witnesses, evidence, factual and legal issues that need resolution, etc. How do you see this tested? Often you'll see this tested in the form of sanctions. If one of the sides sends someone to the final conference who will not be conducting the trial, then the court can sanction. The sanction can be contempt. They can strike pleadings. They can prohibit introduction of evidence. They also may require the disobedient party to pay expenses incurred by other parties unless the court finds making such an award unjust. So if the other side paid to fly out, paid for a hotel room, and then they send a junior lawyer who has no role in the trial, they could tax them for the costs of the non-offending party. Last step is alternative dispute resolution. And this is a process by which a neutral person resolves a dispute or helps the parties resolve their dispute. So basically there are three things that we want to look at. The first is contractual arbitration. And this is a written agreement to arbitrate a dispute is valid or enforceable unless there are contractual grounds for revocation, fraud and inducement, illegality, unconscionability. After the arbiter renders an award, a party can move to have the court confirm the award or move to vacate the award. After the award is confirmed, it's considered final and binding and enforceable as a court judgment. There's also judicial arbitration. It's voluntary, but it's not available in all actions. It's only available in certain actions, even if the parties consent. Within 30 days of the award, the party may reject the award and request a trial de novo. You cannot have judicial arbitration for violation of constitutional rights, certain civil rights actions, in cases alleging an amount in controversy of greater than $100,000. If a party requests a trial de novo, any evidence that the case was arbitrated is generally excluded. Last step is mediation. This helps parties reach a mutually acceptable agreement. The mediator doesn't have any decision-making power, though. They're only there to facilitate the process. The parties have to come to their own voluntary agreement. This can be accomplished by local district rules, so mediation may be mandatory for certain cases. You have to know what the various types of alternative dispute resolution are for preclusion purposes, because that's how it's likely to show up. So the question is it the same claim or the same issue being argued? Okay, so now we are going to go into a review of the civil procedure questions. First, however, I want you to stop and I want you to do the civil procedure questions on your own in its entirety before proceeding to this next slide deck.